Good afternoon, everyone. I hope you are doing okay. Today, the topic that we are going to discuss is the law of evidence. The subject is law of evidence. Since the law of evidence is taught in the later semesters, like in 7th semester, 9th semester, or students who are in 2nd year, 3rd year, 5th year, because the law of evidence requires a prior knowledge of IPC and CRPC. So if you will see, the law of evidence is connected with IPC and CRPC. So friends, always remember that you never have to study the Evidence Act in isolation. Never do that. Always try to study along with IPC and CRPC. So before studying law of evidence, it is very imperative or important that you should have a good understanding of IPC as well as CRPC. Now, given the fact that I suppose that you have a foundation, good foundation of IPC and CRPC, let us begin the study of Evidence Act. Now, this class will be kind of an introductory class in which we will try to understand certain fundamental aspects of Evidence Act in order to have a basic foundation on the basis of which in our later classes we will be discussing certain important principles and rules of Evidence Act. So, if you read section 1 of the Evidence Act, it starts with this act may be called the Indian Evidence Act 1872. It extends to the whole of India, like several other bare acts or other acts says. What important is the last two lines which says that, but the Indian Evidence Act does not apply to affidavits presented to any officer or court, nor to any proceedings before an arbitrator. So always remember, friends, that Indian Evidence Act or IEA does not take into account affidavits. Always remember that affidavits are just a mere declaration made by the witnesses, attested by the deponents, and the affidavits are a mere declaration made on a judicial or non-judicial stamp paper. Whatever I say in affidavits might not be true. What I say in affidavit, it's true to the best of my knowledge. So it is for the court to decide whether it is true or untrue. Whatever the statement that I made in affidavit is true or untrue. So affidavits per se can never be considered as a piece of evidence. At the same time, Indian Evidence Act also clearly says that arbitration proceedings will not be governed by Indian Evidence Act. So an arbitrator is not bound under the Indian Evidence Act. Arbitrator basically arbitrate on the basis of Arbitration and Conciliation Act 1996. Along with that, he comes to a conclusion or decides the case on the basis of principles of natural justice and not on the basis of Indian Evidence Act. So an arbitrator is neither considered as a judge nor the arbitration proceedings are bound by the Indian Evidence Act, and they do not follow the provisions of Indian Evidence Act. So Indian Evidence Act basically applies to civil and criminal proceedings. There are certain provisions which apply to civil proceedings, there are certain elements which applies to criminal proceedings, there are certain provisions which applies to both the proceedings. It depends upon what the proceedings are or facts or circumstances of the cases are. Along with that, the common question that is asked in most of the competitive exam is that whether the Indian Evidence Act is a substantive law or a procedural law. Friends, always remember that Indian Evidence Act is neither procedural law nor substantive law. It is an adjective law. Always remember, Indian Evidence Act is an adjective Indian Evidence Act is an adjunctive law. It contains both the provisions of procedural law and substantive law. That's why Indian Evidence Act must be read with CRPC, must be read with CPC to get an understanding about whole process of law works. So it is very important that you should read Indian Evidence Act in consonance with, together with IPC and CRPC, to get an overall idea about how civil procedure or how criminal procedure works. Now, moving on, now we will study about the interpretation clause, in which we will study certain basic concepts which need to be clear before studying the main portion of the Indian Evidence Act. Friends, always remember that whenever you read a Bare Act, you must read the definition clause or interpretation clause very carefully, because it is the soul of the Bare Act. When you don't know the main concepts, you can never understand the basic principles and rules laid down in the Bare Act. So always read the definition clause very carefully. So when we read section 3 of the Indian Evidence Act, it is a very important section. The first thing it talks about is courts. What is a court? So court, when we plainly read the Bare Act, it says that court includes all judges, magistrates and all persons except arbitrators legally authorized to take evidence. So always remember, friends, that courts include judges, magistrates, but not arbitrators. Since in the beginning also I have told you that arbitration proceedings is not governed by Indian Evidence Act, and arbitrator is not a judge. Arbitration proceedings are governed under Arbitration Conciliation Act 1996. So when we talk about court, the section says that courts include judges plus magistrates. Judges plus magistrate. So always remember that junior judicial officer is called a magistrate, senior officer is called a judge. But when we read along with it section 19, when we read section court with section 19 of the IPC, you will get an idea what a judge is. Judge means not only judges and magistrates who sit in the court, but also includes those people who are empowered under the law to give a definitive judgment. There are panchayats, there are judicial magistrates, there are collectors, there are persons who can pass certain judgment which is recognized by the law. So any person who could give a definitive judgment, who could decide the dispute between two parties and which could be recognized by the law, could also be called as judges. So judges not only mean those persons who sit in the courts, but along with it any person who could pass or give a definitive judgment. Now moving on to the second important portion of section 3. Section 3 also talks about what is fact. Section 3 also talks about fact. So what is a fact? Fact, always remember that fact could be of two kinds. One is physical facts, and second one is psychological facts. Physical, and second one is psychological facts. When we talk about physical facts, means any fact which could be perceived by senses. Now a normal human being have 5 senses: the sense of touch, smell, hear. There are 5 different senses. So whatever you can perceive, whatever you see, whatever you hear, whatever you smell, whatever you touch, whatever you feel through your 5 senses could be called as a physical aspect of a fact. So if you you read section 3, it clearly says that fact means and include anything, state of thing, relation of thing capable of being perceived by senses. So whatever you perceive, whatever you see, whatever you hear, whatever you feel through your five senses could be a fact. Suppose a dead body is lying in a room which is dark, there is no light, and the dead body is rotten. When you enter the room, you smelled the dead body lying there. You haven't seen it, but you have smelled it. That could also be a fact. The fact could also be a thing that A has shot B in front of you, because you have seen it through your eyes. That is also a fact, because now you know that A has killed B and you have witnessed that event in front of you. So anything that you perceive through your five senses is a fact. Now the second part of fact is psychological fact. What is a psychological fact? If you read section 3, it says that any mental condition of which any person is conscious. So any mental condition, suppose a person has killed A, has killed B. Now it could be a fact that A has some enmity against B. It could be a fact that A has certain ill will towards B. It could be a fact that B has beaten up A few days ago and he was very angry, and it could be a fact that A is a very short-tempered person. So whatever the mental state, goodwill, ill will, motive, intention, whatever the mental state of a person could be a fact. So always remember friends, fact could be of two kinds: physical fact which perceived by senses, and psychological fact which shows the mental condition of a person. Now moving on to the next very important concept, that is relevancy. What is a relevant fact? So in layman language, you could understand that what is relevant is that anything which is acceptable, which is genuine, which is not fake, and which has which makes certain sense, which is sensible, could be relevant. Like it could be a relevant thing that you study. It could be a relevant thing. It could be an irrelevant thing that you roam around with your friends, watch movies, because it will not help in your career, right? So anything which will help you, or anything which will help you in your career, or anything which is acceptable because it makes sense, which is reasonable, could be in layman language can be called as a relevant thing. But Indian Evidence Act, when we read Indian Evidence Act, relevancy has a little bit different meaning. If you plainly read the Indian Evidence Act, it says that one fact is said to be relevant to another when one is connected with the other in any of the ways referred to in the provisions of the Act relating to relevancy of fact. Now friends, remember that under Indian Evidence Act, section 5 255 deals with relevancy. So what this section says, that one fact is relevant to another, or one fact could be relevant in comparison with the other only if it falls between section 5 to 55. So if you have to make a fact relevant with respect to another fact, then you have to have some section covering from section 5 to 55 in order to make that fact relevant. Now section 5 to 55 deals with different aspects of relevancy, like plea of alibi. It deals with it deals with motive, it deals with intention, like if A has killed B. So if A has enmity towards B, that could be one of the motive because of which A might have killed B. So if it is a fact if it is a case in which it has to be found out whether A has killed B, the motive which A has for killing B could be a relevant fact. So if it falls between section 5 to 55, any fact which falls between 5 to 55 could be considered as a relevant fact. In India, we follow legal relevancy, not logical relevancy, not logical relevancy. That means in legal relevancy, you have, in order to make a fact relevant, you have to connect that fact between section 5 to 55. But in case of logical relevancy, anything which logically is relevant, which a judge thinks that it is logically relevant, could be admitted by the court. But in India, anything which is logically relevant will not be admitted as a relevant fact until unless it falls within the ambit of section 5 till 55. Okay? Now moving on to another very important aspect or very important principle of Indian Evidence Act, which will help you understand the later concepts, is fact in issue. Fact in issue. So we have read what is a fact. Fact could be anything physical or anything mental. But what is fact in issue? Fact in issue means anything which is in issue, anything which has to be decided by the court to come to a conclusion on the basis of which a judgment could be delivered. Like in case of a will or probate, a person has written a will. So the fact in issue could be whether the will is genuine, whether the property given to the siblings or the son of the deceased is his real brother or his real son or not, whether it could be contended by one of the parties that the handwriting in the will is fake, it is not genuine. These are all fact in issue. Or it could be a fact in issue that if A has killed B, so it could be a fact in issue is whether A killed B. It could be a fact that whether A intended to kill B. It could be a fact in issue whether A has received grave and sudden provocation because of which he has killed B. It could be a fact in issue. So fact in issue, friends, always remember that it is those issues which the court needs to solve or which the court needs to resolve in order to come to a conclusion on the basis of which on the basis of which the court can deliver a judgment. So until unless the facts in issue are not settled, a judgment or decree cannot be passed. So always remember that fact in issue is a very important aspect on Indian Evidence Act. Now fact in issue could be resolved on the basis of direct evidence. If a person has seen someone killing B, or if A has seen through his eyes that A has killed B. It could be that if you have heard a shout when B was shot, it could be that you have smelled the dead body. It could be a fact. But the point is that the fact in issue would always remember that whether he has the intention to kill B, whether he has the whether A is the real murderer or some other person has murdered him or not. These all things will be a fact in issue on the basis of various evidences. Evidences basically are direct evidence which is witnessed by the person who has witnessed the crime, or it could be circumstantial evidence also. Suppose a person is killed but nobody has seen the person who has killed that person. So in that case, what would we be doing is that on the basis of indirect evidence, on the basis of circumstantial evidence, we will draw a hypothesis that no other person but this person has killed that person, because prima facie direct evidence is not available, on the basis of circumstantial evidence or indirect evidences, we will come to a hypothesis or a proposition that no other person but this person has killed that person. So it will be circumstantial evidence, regarding which we take the help of relevancy. So through relevancy and indirect evidences, we try to connect the dots and come to a conclusion. We try to connect the dots to come to a conclusion that this person has committed the crime, or this is the person because of which the other person has been harmed or injured, right? So this is fact in issue. Now the last point is, what is a document? What is a document? Now evidences could be of two kinds. Evidence, when we read about evidence, we must remember, friends, that evidence are primarily of two kinds, that is oral, and other one is documentary. Oral evidence means, if I have seen A killing B, then I will be the oral witness. I will be the witness. I would say in the court that I have witnessed the murder. That will be an oral evidence. In the same manner, what will be the documentary evidence, like in case of a contract, in case of an agreement, in case of a will. When the court requires that will or document to be produced in order to establish the fact that this is the right or liability, in order to determine the rights or liability of a person, suppose in case of a will, if the will is produced in original before the court, then the court can come to a conclusion that the deceased has transferred his property or betrothed his property to that particular person. So only on the basis of the document, contract, will, or any agreement or any documentary evidence, the court can resolve the fact in issue and come to a judgment. So evidences basically are of two kinds, oral evidence or documentary evidence. Now regarding that, what the rule which we follow is the rule of best evidence. Best evidence says that if the court wants an evidence to be admitted, or wants any evidence to be admitted before the court of law, it has to be direct. That means if someone has witnessed A killing B, then that person who has first hand witnessed the crime should make the statement before the court in order to be admitted as a piece of evidence. If I have witnessed, I have said the same thing to B, B has said the same thing to C, C has said the same thing to D. Now whether the D can appear before the court and say that this person has killed that person, no. Because now the authenticity of that oral evidence will be tampered, because when we say one thing to another person, another says to another person, the authenticity or ingenuity of that particular piece of evidence become tampered. So it is always important that whatever the oral document is there, it has to be direct. Similarly, documentary evidence, if the original copy of the documentary evidence is available, the court will not accept the secondary evidence or its photocopy. So suppose if the copy of the will, if the copy of the agreement, if the copy of the contract is available, the court will never accept its photocopy, Xerox copy, pics, or any other form of presentation of the document. Always remember, the rule of best evidence says that it has to be the first hand evidence, that is the direct evidence, the direct witnesses who has witnessed the crime, witnessed the document, whatever that may be, or the original copy of the document itself, because it has to be made sure by the court that no tampering or no manipulation has been done on the part of both the parties. So when we talk about documentary evidence, section 3 says that what is a document. Now in normal nomenclature, when we talk about document, most of the people think that document is anything which is written on a piece of paper. So if we write a letter, if we write a contract, if we write an agreement, if we write anything, that is a document. No. The meaning of the document under Indian Evidence Act is very, very wide. Document not only includes anything written on a piece of paper. Document could also be a picture. Document could also be a sculpture. Document could also be an inscription on a plate or a stone. It could be anything written. Document even could be a graffiti which is made through spray paints on a wall. So when we understand document under Indian Evidence Act, document means, the act says that document means any matter expressed or described upon any substance by means of letter, figures or marks, or by more than any of those means intended to be used or which may be used for recording that matter. So one thing it is important is that whatever you are recording, whatever you are writing, even on a piece of paper, on a metal, on a plate or a wall or a piece of paper, letter, whatever you are writing anywhere, it has to be intended for the purpose of recording. It has to be intended that you want to other peoples to know that you have written certain things and you want to communicate some form of in that form to other people. So it is intended for the purpose of recording that matter. Then only it will be considered as a document. So document, don't understand in the sense that document means only the thing that which we write on a piece of paper. Document could be anything under the Indian Evidence Act. Secondly, one thing always remember, the documents under Indian Evidence Act are of two kinds, that is primary document and secondary document. So as I have already told you, the rule of best evidence always applies. Primary documents means the original copy of the document, not the photocopy, Xerox copy or pics. It is the original copy of the document which carries more weight in the court of law. Secondary document is the Xerox copy, pics or whatever it may be. Always remember friends, secondary document is only admissible in the court as a piece of evidence when the primary document is not available or it could not be made available. Then only secondary documents are admissible in the court of law. So by saying that, I hope that you have understood the basic interpretation clause or definition clause of the Indian Evidence Act and would be able to later on understand the basic concepts, principles and rules laid down in the Indian Evidence Act. Because always remember friends, always read definition clause or interpretation clause of any Bayer Act very carefully, because it will lay down the foundation of your understanding of the entire law itself. That being said, thank you so much for patiently listening to my lecture. I hope that you have understood and have benefited from the lecture for today's lecture. In the next class, we'll be discussing about the evidences and the provisions of the relevancy.